your position for these reasons. Even the ones that disagree with each other are able to say, okay, I disagree, but not for the reasons the other person disagrees, but for my own reasons. In this particular case, we have Judge Chibomba disagreeing with the majority decisions, but she has her own reasons. We have Judge Mnalula disagreeing with the decision of the majority, but with her own reasons. And these reasons are not even the same with the reasons for Judge Chibomba. So that is how the court is supposed to function. That is how we're supposed to improve our jurisprudence.
The judges have been removed on two key issues, according to the judgment. Number one is that they had judicial decisions and they're being accused of having sat alone, and they've categorized it as misconduct. Number two, that they are not qualified to hold that position of judge.
You see,
speak to that. How is it possible for a judge who's been sitting at the court for the last 8-9 years, all of a sudden be unqualified?
The question is, can the Judicial Complaints Commission overturn the decision of the National Assembly when they ratified that appointment?
Because in effect, that's what the JCC has done.
If there is an appointment that has been made, and the whole issue goes through the mill, okay? And there's a decision that these are properly in place. What you do in that particular case, the Judicial Complaints Commission should have gone to court to challenge the qualification of those, in the manner that we challenge the qualification of Judge Shilini. Because Judge Shilini has no experience in constitutional law. He has no experience in human rights. The only thing that is stated in his CV is that there's a module he did in his international law studies, international human rights law. There's a module. And the court ruled that, listen, he has sufficient experience. That is not a decision for the Judicial Complaints Commission. They can't make a decision as to the qualification. They can't make that decision.
But that's what they pronounced.
Yes, if they are going to make that pronouncement, it means that they are interpreting the provisions of the Constitution, and they have no such mandate. They don't have that mandate. So we have a system that has broken down only to feed the ego of one person, and that is President Hakainde Hichilema. And if he could realize that the functioning of a democracy requires that state institutions only work to advance the democracy of a country, not to take away from it. All these organs of governance, Human Rights Commission, Judicial Complaints Commission, Judicial Service Commission, all commissions, as it were, are intended to enhance the rights of citizens, not to take away from them. They're intended to enhance democratic credentials of the country, not to take away from them. You may be curious to note that when it comes to ACC, the funding in the last budget has, to this year's budget, the budget that was announced, has decreased. Or if there's minimal change. But the funding to the Judicial Complaints Commission has increased exponentially by about over 40%.
My God.
That's the funding that has gone to the Judicial Complaints Commission. Why would you underfund the Human Rights Commission? You underfund the ACC, the police, the Drug Enforcement Commission, but when it comes to the Judicial Complaints Commission, you increase the funding by 40%. Why don't you increase this funding to the judiciary, for example? Increase it by 40%, make them financially independent, and you'll be able to do you'll be able to be seen to be trying to protect the values of democracy and human rights. But here you are going to overfund an institution that is intended to discipline, to remove judges. You are enabling them to be able to effectively remove those that you do not want. The problem
do they have powers of adjudication? You didn't answer that question.
Listen, they have powers to determine complaints that are presented before them that relate to misconduct of a judge and that relate to incompetence of a judge. Now, in dealing with misconduct and incompetence, it has got nothing to do with the judicial function of a judge, because the judicial function of a judge it's recognized that there's a chance that a judge may be wrong. And within that, we have said, let us give room for appeal. Otherwise, there would be no room for appeal. The role of the Judicial Complaints Commission is not to correct the judgments of the court in the manner that they are hoping to correct this particular judgment. It's not to review the judgments of the court in the manner that they are reviewing the judgments of the court, in which they are suggesting that the majority decision should have been that it was wrong, it was incompetent, there was misconduct on the part of the judges. There was nothing of that sort. They're choosing to rewrite a judgment that was a judicial function of the judiciary and replace it with their own, which effectively can't be implemented. So they cannot go outside the bounds of determining the incompetence or misconduct of a judge in the personal capacity. But when it comes to judicial decisions, they cannot delve into the correctness or wrongfulness of a decision that has been made.
Do they have powers to reopen the case in the manner that they did? And as a rider to that, I have seen in their final report that they are condemning their own chairperson, Vincent Mwamba, when they've cited him.
You see, that is what would amount to misconduct. Because in these proceedings, we see nowhere where Vincent Mwamba is called.
He's a subject, yes.
No, where he's called in the first place, to be heard as to why he made that decision. So this has been a strange happening, where you find decisions that are condemning persons that have not been heard.
Yes.
That are condemning decisions where the subjects of those decisions have not been heard. It is very strange. We see nowhere where they're saying Vincent Mwamba comes. As a matter of fact, they're saying that Vincent Mwamba misconducted himself.
Yes.
As a matter of fact, I would expect
Why did they say that? Why would you say that about the chairperson?
I would expect that the president removes Vincent Mwamba.
Yes, that's what it is.
Better yet, I would expect that Vincent Mwamba resigns because their commission itself has says he has misconducted himself. Not once, but twice. He refused to reopen.
Is punishable.
Exactly, and misconduct is punishable. As a matter of fact, that is what would be classified as incompetence. They're saying that he was incompetent to do so. And by doing so, he misconducted himself. Why is he still there?
Yeah.
Why is he still there? Why hasn't he seen the back door? Why is he still part of the commission? Are they suggesting that they are there as instruments of punishment for and on behalf of President Hakainde Hichilema? Is there any integrity that is left in him to say, okay, I have been found wanting, so I must resign? But obviously he will not, because he will obviously say, I was not given an opportunity to be heard. So if they are questionable on a decision that relates to Vincent Mwamba, why should we trust them with a decision that relates to the three judges?
Yes, correct.
We can't trust them. We might as well trash their decision and say that the president obviously acted because that has been his desire all along. I think he has misdirected himself on many fronts, not just on the economic front, but on the front that has to do with issues of separation of powers, but also policy when it comes to international relations.
Yeah.
In a very long period of time, we are finding ourselves where we are not seemingly getting along with Zimbabwe. We're not seemingly getting along with some of our neighbors. What is happening to our country? What is happening to our foreign policy? What is happening to our economic policy? What is happening to the observance of human rights? What is happening to the observance of the rule of law in this country? We're looking at all these things, and everything is stopping at the president. Is there anyone who is helping the president do the right thing? But like I said, you can never convince a monkey that honey is sweeter than bananas. He seems to have his own modus operandi, such that when you tell him you can't do this, he asks, why not? I'm president, I can do all things. He's fixed in his ways.
Yeah. He actually expresses frustrations all the time.
Exactly.
That people are steeped in bureaucracy and they wouldn't allow him to move. He doesn't seem to respect rules and regulations.
Exactly.
Another matter related to this, before I let you go, Counsel, is the issue of another reopening of a major case, the case of eligibility for the former president, Edgar Lungu. This matter was settled. several times. I don't know how many times it was settled, you tell us. But the part I'm interested in, because you're appearing before the same court and you may not discuss a particular details, the part I'm interested in was this pronouncement by the court, especially by the judge president on you, trying to send you to LAS. But before you answer that, speak to the issue. Can you reopen case? It has become fashionable. Here, JCC reopened the case as soon as they had new commissioners in Jala, and other two members of the new commission. They reopened the case for the three judges, and we've seen an adverse decision. We are now faced with the eligibility case of President Lungu. Even if it has been settled by the same court, and in many cases, same judges, other than a few that have joined it, it has been reopened. And then you had made this application for their recusal, and then they made those rulings on that. So you have those three questions.
It's a loaded question.
Yeah, let's start with
it's a very loaded question. But
how many times has this case been heard and settled?
Yeah, but just for purposes of context, decisions that are made by institutions are decisions for the institutions and not the individuals that are there.
Occupying it.
We can't have a situation where a decision changes depending on who is
the new
there
office holder
as an office holder. We have seen the decision of the Attorney General changing because there has been a change of office bearers in the eligibility case. And we had occasion to argue before the court. So this court is not like the Attorney General's chambers who are flip-flopping. Even when ordinary, they shouldn't be flip-flopping. And the very important issue is that there must be certainty in the law, where if there's a decision that is made and you have a similar set of facts, you must be able to know that there's predictability in the manner that the court is going to make decisions. If there's no certainty or predictability in the manner that the court is going to make its decision, that's only a recipe for chaos. It's a recipe for chaos because the trust in the system will be eroded. Even the very things that President Hakainde Hichilema says he wishes to bring, such as foreign investment, maybe it explains as to why the promise for foreign investment is not coming in, because one of the things that an investor looks at is how is the dispute resolution mechanism of your country.
Yeah.
Do your courts follow the law as it is? Is there certainty in the manner that they settle their disputes?
Yeah.
If they have problems with that, they will not come. If they think that your courts are capable of being manipulated to decide in a certain way, they will not come. Perhaps it explains the economic downturn that we have, because everything that has been done by this government has been to the extent that you can no longer trust our institutions of governance, you can no longer trust, or there's diminished trust in the certainty and predictability of the courts. And that is trickling down to organs such as the JCC. Now, we are awaiting the judgment on the 10th of December. It will be curious to see that there's a shift in position. Curious because in the Danpule case, in the way we argued, we said you made it very clear in no uncertain terms that he was eligible. In the case of Bampika Palasa, you re-emphasized that particular position and said, we have already decided one too many times that he is eligible. Then came the Sishua case, as well as the Legal Resources Foundation case, which were put together, and the decision was made. And the court even warned in that case and said, listen, it should not be the practice that you keep pressing and pressing a matter on an issue that has already been resolved, hoping to get a different result. You can't do that. So when this matter came up the 5th time, because I'm counting the Sishua case and the Legal Resources Foundation, yes, as two cases that were consolidated. The 5th time now it comes up, we say, listen, on a preliminary issue. You have dealt with this matter, and you can't be seen to be reopening this matter. And now we have argued. They said, okay, you have raised this in your defense, and we'll hear you, and we'll hear what the other party has to say. And we went and argued to say, even though these people want you to reverse your decision in this particular case, they have not prayed for that answer. They have not asked you specifically to say, reverse this decision that you've made. And of course, we've argued other matters. And we're looking forward to see whether
how they will determine.
The court will remain certain, whether the court will not behave like the Judicial Complaints Commission. We are yet to see that on the 10th of December. We are hoping that they do not behave like the Judicial Complaints Commission. We're hoping that they're able to stand by the decisions that they made 4 times before. Yes, we're hoping for that. And you asked a very interesting issue as to the question.
You had an application. Yes, you had an application of recusal.
An application for recusal.
I think that's a normal application in any normal matter. See, you felt that the 3 judges were conflicted, and you raised a petition, but the answer was an angry answer. Even the judge president asking the Attorney General to refer you to LAS. Was there anything wrong with raising the recusal?
The reason the law has provided for applications for recusal is because the law envisages that there will be situations where that application will be necessary. Yeah. And this was one of them. This was one of them because the apprehensions of a person that is going before the judiciary have to be taken care of in the light of having a fair hearing. Yeah. A fair hearing is guaranteed by the Constitution. Every person should have a fair hearing. Yeah. Any departure from that, even a perception of a departure from it, should be avoided. And this application is brought. And we're saying, listen, there is a close association between you, Judge Shilimi, and President Hakainde Hichilema, who is likely to be a beneficiary of these proceedings. And we think it may not be a good thing for you to sit. Our client is apprehensive that you may not be perceived to be impartial. Now, the issue is not whether actually the person may be partial, but the perception of it is sufficient. Now, the ruling comes, and he says, yes, there is a connection, but it's remote. And we're saying the very fact that the connection is there, no matter how remote, is sufficient ground for one to recuse themselves. And the person says, no, it's remote, I will not. Okay, I will not recuse myself. Now, I think the judge should have gone further and says, although I'm of the view that the connection is remote, I will recuse myself for purposes of the perception, not being that I may not act in this manner. My view is that it should not have gone further to say, I will therefore sit. It shouldn't have been.
After establishing
a
link, although he deemed it himself to be remote.
Exactly.
But he then chose to sit on the case.
Yes, chose to sit on the case. And the ruling by Judge Mnalula, it was a very, very interesting ruling. We were representing a client who had certain concerns.
She used the word modus operandi.
Yes.
She says, every time I've sat in your case, your law firm, Makebi Zulu, you seem to have created a modus operandi where, you want me to recuse myself.
And then she says, why me?
Why me?
Exactly. No, I read that ruling. It was a very interesting ruling. But perhaps for
our viewers,
our viewers, and for perception to the whole issue. See, previously in the Milingolungu case, there was an application that was made before the court. And I did not think that she would go that far to isolate the lawyers and deal with the lawyers in the manner that she did. If she intended to go in that direction, during the time we were submitting, she should have at least asked us to say, listen, why is it that you are so concerned about my sitting here? In that other case, you made a similar application
of recusal.
Of recusal. Is this your modus operandi? We would have been heard. We would have been heard. We would have explained to her, would have explained to the court that no, this is not our modus operandi. In that particular case, we acted this way because of these circumstances and these facts that we're faced with. And it was necessary to protect the interests of our client to be able to delve into that issue and make that application which we make. But to come in this particular ruling and make such pronouncements and that ruling becomes part of the record is pretty much unfair because we were not heard. And no party should be condemned unheard.
No, when there was an application for recusal, we were hearing issues of the recusal.
Exactly.
So, but in the judgment, the judge brought past issues.
Yes,
that
past issues.
You even in the other case, you applied on the recusal.
Now, let me tell you something that happened in the other case. There was a motion that was raised. The motion that was supposed to be heard. And State Counsel Sakwiwa Skota was leading the team.
Yeah.
Okay, so it is not correct that it is our firm because there are 3 firms that were involved in that particular case. We were part of that case. And in that case, when the motion was filed, the matter came up before court. And it was brought to the attention of the court to say, we can't proceed with the main matter because there's this motion that has been raised. There and then, herself being the person that was presiding over those proceedings says, no, we will not go ahead to hear that motion. She made a ruling against that particular motion. So it was shocking. It was pretty much shocking. And the court was asked to say, let's retire to chambers and discuss this matter. That was granted. And when the matter came up in chambers, it was presented to them to say, listen, you can't throw out this application without hearing it. You can't throw it out without hearing it because we are of the view that the opinions of the other judges on the panel was not taken into account. So at that point, the court itself decided, okay, we are going to hear your application. We will hear this matter. And concern was raised to say, okay, you have already expressed your opinion over this matter. You threw it out before hearing it.
Yeah.
Therefore, you can't sit. That issue was raised. And in that matter, when the motion came up, she didn't sit because she had already expressed her opinion on the matter. So if it's that issue that she was referring to, we had justifiable cause to raise the issue because she made a decision, in our view, without consulting the other judges that were on the panel, and she expressed her opinion even before hearing the parties. And that was not correct by any stretch of imagination. That was certainly not correct. And obviously, that would lead anyone in that matter to say, no, there's a perception of bias on your part. You don't like me. You don't like the way I'm proceeding in this matter. And therefore, I don't think you should be sitting in a matter. So that is what happened in that case.
No, the two issues were conflated.
Exactly.
I think they were not the same, and there was no justification to import it into that ruling. But they were terribly emotional. As soon as I read the 3 and their justification, I said, that's a reason they should actually recuse themselves.
As a matter of fact, that should have been the reason. The very fact that in fact, it is a provision of the law. If you're uncomfortable with a lawyer for a litigant, and you have issues with a lawyer for the litigant, that should be reason enough to say, I will not. Otherwise, you'll make a decision hoping to punish the lawyer for the litigant when it's affecting the litigant and not the lawyer necessarily. So that, in my view, should not have been part of that. Firstly, because we were not heard on that particular application. Secondly, because it gave a perception that she had problems with the lawyers. And as such, she may be perceived not to make a correct decision on the fact that she has problems with the lawyers, and that should have been reason enough for her to recuse herself.
So what will happen to the judiciary with the dismissal of these 3 judges who are now total 7, with the reopening of old cases that by all legal standards are deemed determined and settled, but now there is no guarantee that a matter against anyone can be reopened and reheard? What's the status of the judiciary?
Unfortunately, that seems to be the precedent that is being set. And it will be sealed based on what the decision is going to be on the 10th of December. So we're curious to see what the decision is going to be on the 10th of December, in which case all lawyers should be ready to say, okay, that matter where the Supreme Court or indeed the Constitutional Court made that decision, we can always go back and have them change their mind. Yeah. If they don't change their mind this time around, we'll commence another action. If they don't make a different decision, we'll go ad infinitum. And that really kills the issue of a matter being res judicata. Res judicata is a legal concept that means that matters should be settled with finality, and that you can't keep dragging the same person to court over and over and over again over the same issues. There must be finality to the resolution of issues. That is what...
I saw the Attorney General argue very, very strongly that the court has powers to review its own decisions. Does the court have powers to review those decisions?
See, the court has power to review its own decisions. That we can't take away from the court, the power to review its own decisions. But there must be a specific application made to the court to review that decision. Or in circumstances where another matter arises, the court can reverse their previous decision based on the law existing at that time, or indeed there's fresh information that has come to their attention, which may not have been there at that particular time. But in this particular case, none of those issues exist. The Constitutional Court, in more cases than many, has pronounced itself to say, we are bound by our own decisions. And they have to put that into practice. We'll see if that happens on the 10th of December.
They'll be bound by their own previous decisions.
Exactly.
Counsel, there are many things I want to speak to you about, especially because of what is happening. Recently, the Electoral Commission of Zambia, Chairperson Mwangala Zalomis, appointed an electoral reform technical committee to review the constitution and legal provisions that hinder her work as ECZ. I found that very, very strange. First of all, ECZ and Mwangala Zalomis are creatures of the Constitution. Do they have powers to set up committees to begin to hear reforms to themselves? I say this because previously, any reforms have been driven by either the president through the Commission of Inquiry or through the Zambia Law Development Commission, where they would make recommendations. But here now we have a body in ECZ where Mwangala Zalomis has appointed the Electoral Reform Technical Committee and set them out in the country to gather views about what they think about the Constitution in relation to elections, what they think about the law in relation to elections, what they think about her body ECZ, and she wants to make recommendations for the law.
Okay.
There's another matter happening in Parliament where also the Speaker seems to have started a process to amend the Constitution on the so-called non-contentious issues. What is happening to our law reform? Is that how it is done?
You see, that's why I keep telling you that it is difficult to convince a monkey that honey is sweeter than bananas. The very fact that President Hakainde Hichilema thinks he has control over all these institutions, it's difficult to tell him that you can't do this because he thinks it's a company, I'm the CEO, therefore I call all the shots. You can't run a country like an enterprise. I was running Eastern Province. I knew where my bounds were, where the line ministry works and does its job, and where I come in to supervise the works that are being done by the line ministries. It did not put me in charge of the line ministries. I could not make a decision that was contrary to the decision that has been made by a minister in a line ministry. Although those ministries were under my domain in the Eastern Province. The decisions of the local authorities, those were under my supervision, but I could not replace my decision for theirs, or their decision for mine. So there are limits as to what can be done. Institutions of governance are governed by the statutes that creates them. And in this particular case, you have the Electoral Commission of Zambia, which is regulated by its act, as well as the constitution. And everything that they do has to do with what is provided in the law. There's nowhere in the law where they said they have a right to make recommendations as to how best they can carry out the functions of their office. Where there's that power, it is specifically provided for. Now you have the Law Development Commission, you have the Minister of Justice, you have all stakeholders that have a part to play in what the Electoral Commission of Zambia does. And the essence of the Electoral Commission of Zambia is to carry out elections in a free and fair manner, in a manner that satisfies the will or promotes the will of the people, promotes democracy, promotes the rule of law. To assume a power that you do not have, to say we are going to collect views as to how best we can work better as a commission. You are saying we have failed to work within the mandate that has been
provided for.
And we are going to get views from around the country as to how we should work. Have you told us how you have failed in the first place? What is not working there? Why are you going to collect views when you are the ones that are having problems with how you're working? Why are you collecting views? You're collecting views from people that are not working there. But in the meantime, the way that you're operating is what the Zambian people have decided is the way you are going to operate. Your competencies can only go so far. This is the power that we're giving to you. And you are going to the people to beg to extend your power to do what you think you must be doing. How did the previous or successive commissions perform within the limits of the power that was given to them? What were the failures? They have not told us. In any event, I did not see anything in the budget line for Electoral Commission of Zambia to carry out that particular investigation exercise. So who is funding it? How is it being funded? Where are the monies coming from? Is it another issue of abuse of office? Is it another issue that will be a subject of investigation at some time in the near future? Where is whoever is in charge of the commission getting this power to carry out these functions? I think that should be an issue that should be interrogated. And they can't do that without the blessing of the executive. And they are doing so wholly with the blessing of the executive. And illegally the executive, so. Exactly, and illegally so. Even when it comes to the National Assembly, the Constitution is a document for the people. Nothing emanates from the National Assembly. The National Assembly receives and deals with matters. Nelly Muti cannot on her own accord say, we need to amend the Constitution. She has no such power. All that power is reserved in the people. All that power has to come from the people. The need to amend must come from there. Yes, from there. I know of no legislation that first emanated from National Assembly. It has to be moved by the executive. If not by the executive, it must be moved by a backbencher. If not by a backbencher, as a citizen, I can petition the National Assembly, petition that a certain law be enacted. I could do that, and that is obvious, has to be done by the members of Parliament and not the Speaker of the National Assembly. They are not the author of any law. Neither are they the omega of any law.
No, they forget they are mere presiding
exactly.
officers. They think the powers of the Speaker extends to doing the jobs of MPs.
Exactly. So to preside over a matter does not mean you initiate the matter. You preside. You're a referee. You can't have a referee going to say, okay, next week is Zambia versus Morocco playing. You're going outside your bounds.
Yeah.
Your job is to get the instructions. Okay, Zambia and Morocco are going to play. You are going to officiate.
Yeah.
Your role is simply to officiate and not to start. So it's a rogue parliament that we have. It's a rogue parliament that we have, and we need to bring it back to where it's supposed to be.
And finally, the state of human rights. You know, these arbitrary arrests, extrajudicial killings, long detentions,
freedom of expression,
and then the freedom of expression is
freedom of association.
Yeah.
Yes, we have those problems, and there's nothing that the president can say, what information minister can say, PS information can say, that would take away from the fact that Zambians have seen that there's been an erosion of the freedom of expression. For the first time in this country, we have seen more cases of seditious practices, a matter that is being used to stifle dissent. Yeah. The very fact that you do not like what a citizen has said does not mean they've committed an offense. The very fact that a member of the executive disagrees with my opinion does not mean that then I've committed an offense. But it appears that if a UPND cadre disagrees with the position that has been expressed by a member of the opposition, they'll go to the nearest police, and it's seditious practices. That is what has been going on around. And the trouble is, all the watchdog institutions, the CSOs that used to speak on behalf of people, have suddenly gone to sleep.
They are dead.
We can only conclude that perhaps the little positions that have been given to some of them that were very vocal in these issues have tended to be issues of bread and butter that they don't wish to abandon at this particular point. But I think rights of individuals must be respected. Let individuals express themselves. I keep saying this. Democracy is a marketplace of ideas. You can disagree with me, but I must be able, or you must be able to protect my right to hold the opinion that you do not agree with.
Yeah.
I must be able to express my opinion without fear, because that is guaranteed by the Constitution. So the mere fact that I think that the position that you hold is not a correct position, notwithstanding that your position, if held by so many people, can lead to a crisis, doesn't matter.
Yeah.
It doesn't matter. If someone is going to say, okay, look at what is happening in other countries. Maybe our country would be better if what is happening in another country would happen here. That is my opinion. That is the opinion that I hold. You may not disagree with it. It may be suggestive of an illegality, but I hold the view. You must be able to protect my right to say what I say. Because if I'm going to keep it in my head, that is not what we structured our Constitution to be. We did not structure it so that people keep their thoughts to themselves. They must be able to express those thoughts. As a matter of fact, the very things that people are talking about, things to do with tribalism, things to do with violence that is being perpetuated, tribal remarks that are being made, you will see that these are issues that people discuss on the tables in their kitchens.
Yeah.
When they bring it out, you say you shouldn't be talking about that. It is true that the extent of tribalism that is being exercised or experienced is much more rampant than ever before.
Yeah.
It is true that the people that are being favored are seemingly coming from a particular region. It is very true, and people are able to justify that. They look at the promotions that are being made. They look at those that have been laid aside and stopped from working. We have over 430 civil servants that have been surrendered to cabinet that are staying at home, doing nothing, getting paid. And if you look at the regions that they come from, you'll be able to say that, okay, there seems to be an issue that is going against these people that are coming from this region. Yeah. Those sentiments used to be made previously. Those sentiments are being made now, especially now they are at a much more large scale, because the experience, everyone is experiencing it and saying it should not be so. And the people that are talking about that are talking about in the sense of condemning it, that it should not be the norm. They're not talking about it in the sense of that it should be promoted. If they were saying it in the sense that it should be promoted, therein lies an offense. Yeah. If they are talking about it in the sense of condemning it, then you should protect their right to say it, because they're saying this illegality should be stopped, and they're not saying this thing should be perpetuated. But instead you are having people that are saying, no, let him come here, and we are going to circumcise him. Those people are not being punished. Yeah. And those people are saying, no, no, you can't do that. You should not be doing what you're saying should be done. Are saying, okay, because you said that, you are suggesting that people should be violent. What you said is capable of making people rise and be violent. No, no, no. It's not about the capacity to make people rise and be violent. The person that you should be punishing is the person who rises and becomes violent. Because the person who says or condemns a particular act says this is wrong and should not be done. Yeah. Yes. Yeah. Yeah. But we seem to be having problems.
No. Clearly, there's that threat of freedom of expression, freedom of movement, and you just can't believe that we are in a democracy. And I believe all those reports saying there is a dictatorship under reign currently. Honorable Makebi Zulu, you stopped me from calling you Honorable Makebi Zulu. Mr. Makebi Zulu.
Yes, sir.
I think it's been an interesting journey. I hope to bring you just to speak to specific issues. I brought you generally to, I think, for the country to know who you are, who Makebi Zulu is, what forms Makebi Zulu, and why does he comment about the issues he comments about. I'm glad that you took the particular cases of the 3 judges and the issue of the eligibility case to demonstrate that you just can't reopen cases in the manner they are reopening. And you just can't abandon your previous ruling of your office because you are the new office holder, What are your last words?
Well, perhaps my last word is that this is our country. My last words, as it were. This is our country. We need to protect it. It is incumbent upon each and every one of us to protect the democracy that we have. Respect for the rule of law, that must be paramount. And this government must switch to that particular position. Because it appears as though now the modus operandi is, let's clamp down on the opposition. Let's choose who our opponents are going to be in the next election. That should not be the case. Every citizen should arise and protect the democracy of this country. They should arise and ensure that the opposition is able to speak and speak freely as regards matters. They should allow the public to be able to weigh the opinions of different political parties for purposes of making a formidable decision as to who they want to lead them. You can't be the one to want to choose what the people are going to hear, what the people are going to say. We had an interesting issue where you go to a private property called the Cathedral of the Child Jesus and say you can't gather here. You stop the Archbishop from going to gather there. What gives you the power? What gives you the nerve to stop someone from getting onto their own property without justifiable cause, without a court order? The invasion on people's privacy has been exponential in this regime.
The former president wanted to go and lay raids yesterday, and they sealed the area.
They sealed the area. There's been this utter abuse of the police, which should not be the case. We have degenerated into a police state. Hakainde Hichilema used to say, Zambia has become a police state. It's 10 times much more under his watch. And it can only be that because he chose to be in charge of all law enforcement agencies, he's the one that's calling the shots. It's time for him to wise up and protect this country, not just for himself, for his children and children's children, his great-grandchildren, and for his legacy as well. He shouldn't go down in history as a person who brought the democratic credentials of this country to its knees.
Yeah.
Currently, democracy of this nation, the rule of law, is on its knees.
Yeah.
And it is not President Hakainde Hichilema who will lift it up, because he has shown in the 3.5 years that he's been there that he has failed, and failed lamentably. He should wise up and do the right thing.
That between honey and the banana, you think that the banana is sweeter than honey.
He thinks a banana is sweeter than honey. You can never convince him that honey is sweeter than a banana.
And if you put a bag of money here and the banana, he thinks that the banana is better. He doesn't know that the money can buy more bananas. Makebi Zulu, constitutional lawyer, renowned Lusaka lawyer. You've seen him take up those big cases in our country, and he's been a regular commentator on public, civic, and legal issues in our country. I was privileged to host him to discuss the state of democracy and human rights in Zambia. It's a matter of serious worry, and it's been documented by various international reports. In the past, Honorable Makebi Zulu, I'm disappointed. In the past, it will be our own civil society groupings that will demonstrate that the rule of law is under threat, that democracy is threatened, that will highlight these human rights issues before international reports caught on. But now it's the opposite. It's like all our civil society and human rights commission are literally silent or intimidated or reactive, whatever it is. We are now allowing international bodies to determine and decide about who we are, instead of our own institutions highlighting. But I guess that's what dictatorship does. It cows everyone into silence. Dear viewers, until we have another guest next time, God bless you, God bless our country, and shalom, shalom.